Good afternoon. Thank you for joining us in our final lecture for the Race, Security, and Empire lecture series of the 2022 and 2023 academic year, hosted by the Rutgers Center for Security, Race, and Rights, which is housed in Rutgers University, Newark, and in the People's Electric Law School. And part of our mission at Rutgers Newark is to address and discuss controversial but timely issues that require us to think critically about how systems of law and politics and economics and society produce inequality. So today is a topic that is quite relevant to us here in the US, but as well internationally as well. And it is certainly my honor to be hosting Professor George Bisharat, whom I will introduce in a minute after I just encourage everyone to follow the Center for Security, Race, and Rights at csrr.rutgers.edu. And if you are on Facebook, Twitter, or Instagram, RUCSRR or Rutgers CSRR, please do follow us. And we are the first and only civil rights center at a U.S. law school that focuses on the civil and human rights of Muslims, Arabs, and South Asians. And today's lecture, which is entitled Mobilizing International Law and Social Movements in the Palestinian Struggle for Justice, is squarely in line with that mission, because you cannot understand the way in which Islamophobia, Orientalism, anti-Arab racism, and anti-South Asian hate operate without understanding what is happening abroad, especially in the countries of origins from which many of these communities may have immigrated from in the last decade, few decades, or even over a century ago. So it is my distinct pleasure to be hosting Professor George Bisharat as our lecturer today. He's the Honorable Raymond L. Sullivan Professor of Law at the University of California College of Law in San Francisco, formerly known as UC Hastings College of the Law, where he has taught criminal procedure and practice, anthropology of law, Islamic law, and other topics since 1991. Professor Bisharat holds a PhD in anthropology and Middle East studies from Harvard University, a JD from Harvard Law School, and an MA in history from Georgetown University, as well as a BA in anthropology from UC Berkeley. Before teaching law, Dr. Bisharat was a trial attorney in the Office of the Public Defender for the City and County of San Francisco. He writes frequently for both academic and popular publications in the United States and abroad, and is in demand as a media commentator on Israel-Palestine and on issues of racial inequalities in the criminal justice system. He is an international affiliate of the Institute of the Comparative Study of the Administration of Conflict at the Federal University Fluminense in Niterói, and has spoken and published in Brazil in both English and Portuguese. He is a senior fellow at the Center for Security, Race, and Rights, our center. And Dr. Bisharat is also a musician and a big heart, and as a big heart, George has released 5 albums of blue jazz music to critical acclaim and award nominations in the blues world. His latest release is titled Cut My Spirit Loose and came out on March 24th. So without further ado, we are so delighted and so thankful to have Dr. Bisharat here today, and I will cede the floor to you, Dr. Bisharat, for about 20 or 30 minutes. And then after that, we will go through a Q&A with the audience, at which point, hopefully, we'll have a lively discussion. So welcome.
Thank you so much, Professor Aziz. It's an honor, honestly, to be part of this great lecture series, to be a senior fellow with the center. Ramadan Kareem to all of those Muslim brothers and sisters who are celebrating this month. It is my objective to speak for 30 to 35 minutes. I'm going to start with a roadmap of where I'm going to be going, and then dive in. And I will, of course, look forward to your questions and discussion after I'm done. So if you read the abstract that I submitted for this talk, I started with this phrase, law is where power announces its victories. So the first thing I want to do is to explain what I mean by that. Secondly, I plan to highlight some specific features of international law that render it particularly vulnerable to exercises of power. And then third, I want to illustrate how this principle plays out in the case of Israel-Palestine. Then I'm going to turn to the question of whether this general dynamic can be altered, that is the dynamic of law being primarily an exercise of power, whether it can be altered in such a way that rights of Palestinians and rights of others in question can be vindicated by law. Hopefully, I will also have time to say a few words about the crime of apartheid. And then finally, I will argue that law's role in the broader struggle for Palestinian rights is unlikely to be more than subordinate, and it's only going to advance. It will only be a positive contribution to that struggle through the thoughtful and deliberate integration with other forms of struggle, with other social, political, and other forms of struggle. So that's kind of the roadmap of where I'm going to go. Now, law is where power announces its victories. I devised that phrase hoping that it would be a sort of a pithy reminder of the fact that, simply put, power produces law. Law does not produce power. Legal outcomes, just to spell it out a little further, and I mean by that legislation, court decisions, and the whole gamut of what goes on in the legal realm, generally reflects the existing power balances or imbalances, as the case may be, between actors outside of the legal system. And from my long study of this dynamic, it seems to me that there is little independent potency in law to shape social and political realities. Is this always true? Of course not. Law can produce justice on occasion, and weaker parties can sometimes prevail. Doctrine can trump power on occasion. We also have to remind ourselves not to take a simplistic view, or not to have a simplistic understanding of what power is. There are diverse forms of power. There is military power, economic power, diplomatic power, but there's also narrative or discursive power. And all of these different forms of power interact and help to produce legal outcomes in courtrooms and elsewhere. But the moments in which justice prevails, in my view, are relatively rare and fleeting. Over time, power consistently prevails. When it doesn't, it changes the terms of the game. In the United States, for example, the rise of consumer law, let's say of products liability law, begat arbitration clauses. In other words, corporations responded to increasing rights being recognized as legal doctrine and enforced in courtrooms by making sure that many disputes with consumers were simply taken outside of the courtroom into arbitration. And for a long time, these clauses were more or less obligatory, and we all signed them because we didn't really have much of a choice. Now, I think it would be fair for you to ask, am I only stating the obvious? I don't think so, at least not for people of my generation. I was born in 1954. That was the year that Brown versus Board of Education was decided by the U.S. Supreme Court. Incidentally, I was also born in Topeka, the city from which that case arose, Topeka, Kansas, that is. And that was the case in which public school education in this country was desegregated. And I grew up in a period of optimism about law's possibilities to effectuate positive social change and to serve justice. There was a lot of evidence to support that. Here in the United States, the victory after victory by the NAACP Legal Defense Fund showed that. We had, Thurgood Marshall on the U.S. Supreme Court. For several decades, we saw the steady expansion of rights, including the women's rights to choose in Roe versus Wade in 1973. On the international stage, as this was going on in the United States, there were many encouraging developments on the international stage. We had, of course, the post-war birth of the United Nations. We had the Nuremberg trials, in which for the first time perpetrators of vast wrongs were held to account. We had the development of the concept first, and then of the actual covenants codifying human rights. We had the definition of the crime of genocide for the first time. And then we also had the process of decolonization, which had legal dimensions as well. This was followed in the 70s and the 80s by the global emergence of human rights NGOs. This was a worldwide phenomenon. And all of this left many of us with the sense that law as justice, in contrast to law as power, was ascendant. And that's what drew many of us, myself included, into law. Now, in retrospect, much of this optimism was probably misplaced. So we in the United States underestimated the extent to which positive outcomes in the courtrooms, let us say for civil rights, were the product of the power exerted by Black people and their allies in the streets. I'm not certain that we would have had the same civil rights victories in the courtroom without Malcolm X and the Black Panther Party, who provided the implicit "or else." And we might also have overlooked the reality of power dynamics in a bipolar world when the Soviet Union and the communist world more broadly were genuine rivals on the world stage. US elites had to be mindful of how the treatment of people of color in this country was a vulnerability on the world stage. Nor in this period was the United States the global hegemon that it has become since, that is now capable of simply issuing worldwide edicts, like sanctions against Iran, for example, without real pushback. So in retrospect, this period, let's say from the 50s to the early aughts, looks increasingly like an exceptional period in the life of the law, certainly in this country and probably globally as well. Those of you who are in your 20s and 30s, you have grown up in a different unipolar world, one in which you are witnessing the rollback of rights, as in the Dobbs decision domestically, and globally, the occlusion of, or the overtaking of, replacement of international law in favor of the US-led rules-based international order, which suspiciously resembles an elevated form of heads I win, tails you lose, and a reversion of law to the norm as primarily the expression of power, sometimes naked expression of power. Now, after that uplifting beginning, let me talk to you a little bit about some of the weaknesses that I see in international law and some of the reasons for which it is particularly vulnerable to exercises of power. So, first of all, the terms of international law are often indeterminate and contested. This is true, of course, of all law to some extent, but it is true to a greater extent of international law. What I mean by indeterminate simply is that law does not clearly dictate or determine outcomes. There's a lot of play, there's a lot of uncertainty about the application of legal principles to particular circumstances. It doesn't give you a clear, determinate answer as to how a factual circumstance should be resolved legally. Take as a simple example the principle of distinction, which is part of international humanitarian law, which says that that armed forces engaged in war are required to distinguish between combatants on the one hand and non-combatants or civilians on the other. You would think that that's fairly clear or fairly straightforward. It simply isn't. If you look at the literature, there's a great deal of contestation and argument about who is a combatant and who isn't in a particular circumstance, and it has led to very heated disputes. Now, why is international law relatively more indeterminate than domestic or municipal law, as it's sometimes called? It has to do partly with how international law is made. We don't have a global legislature. That is not the function of the United Nations, for example. It does not generate law, the Security Council can generate binding decisions, but there's no law legislative function as such. And law is, on the contrary, primarily made either by treaties, which are contractual agreements among states, and to a considerable extent still by custom, which is, and customary international law basically is the regular practice of states, what states actually do in the international realm that is accepted as lawful by the international community. So this role of custom in making law, first of all, favors powerful nations who are the ones capable of doing and practicing and not generating objections from others. What it also means, however, is that you sometimes cannot distinguish, or it is difficult to distinguish between a practice which is simply illegal, for example, assassination or targeted killings, which has been employed both by Israel and by the United States, or is it possibly a newly emergent international legal norm? There is, and there's a great deal. How many nations have to agree that this is actually, a newly emergent legal norm, or a norm that's going to be accepted as a part of customary law? Which nations, and how must they show their consent or their assent to the emergence of this new norm? Many uncertainties here. So all of this sort of creates indeterminacy in international law that is greater than that of domestic law. And then, of course, to top it all off, there is the absence of consistent, effective enforcement. Most international law enforcement is done not in international fora like the International Court of Justice or even the International Criminal Court, but in national courts. So international law for most nations, including the United States under our Constitution, and in the fundamental laws of many other states, whether they have constitutions or not, international law is incorporated as part of domestic law. So most enforcement of international law goes on in national courts, and those courts are often susceptible to political pressures. They also generally observe the doctrine of sovereign immunity, meaning out of basic respect for the sovereignty of other states, they're not going to try in court, prosecute heads of state or other high leaders of other states in their national courts. The respect for sovereignty means that those people should be tried for any wrongdoing in their own nation. Now, that then you can say it sort of is like the fox guarding the chicken coop, because it means that the courts that are considering international law claims are typically those of the offending parties themselves. And certainly this is exemplified in this is true of international law as it unfolds in Israel-Palestine. We have, in the history of the issue, which goes back, let's say if you go back to the founding of the State of Israel to 1948, we have one decision by the International Court of Justice in 2004 concerning the legality or illegality, actually, as it found, of Israel's separation barrier or separation wall. So we have that one decision. We have scores of decisions, on the other hand, by Israel's Supreme Court invoking international legal principles. Now, let me turn to I believe it is my third of five or so main points that I outlined for you in the beginning. Justice and power in the case of Israel-Palestine. This, I think, is where international law's vulnerability to power is graphically evident. There is a whole litany of examples I could provide you in how power has perverted international law in its application to many of the questions that have been raised in court concerning or arising in Israel-Palestine. This is certainly true in the record of Israel's Supreme Court. As I said, there have been scores of cases raised in the Supreme Court, and only rarely, only occasionally has the Supreme Court imposed limitations on the actions of, let's say, the Israeli military in regard to Palestinian property and lives. So, for example, more than 40 years ago, in 1979, in what is commonly referred to as the Ilan More case, the Israeli Supreme Court said, yes, your challenge to a settlement that was being set up in the West Bank is valid, and settlements can only be private land can only be temporarily requisitioned for out of reasons of military necessity. And in this particular case, the court was not convinced that that was true. And so a settlement was stopped, at least for the time, for a brief period of time. That actual settlement was moved a few hundred yards and was built. And as a result, the military government in the Israeli occupied West Bank simply shifted legal tactics and started challenging Palestinian ownership, possession, and use of land on a different basis, on the claim that much of the land of the West Bank was in fact state land and not private property. So it simply dodged the Supreme Court ruling, and then all of the the procedures that were set up for Palestinian landowners to challenge under this new tactic were ordained by the Israeli Supreme Court. And the end result you see on the ground today, which is in the form of more than 250 Israeli settlements, some formally established under Israeli law, others simply set up by private actors, and somewhere in the neighborhood, somewhere between 600,000 and 750,000 Israeli settlers. So no effective bar to the settlement project as a whole. This meaning the sort of the perversion of, or the blunting of law as justice, and the exercise of power in such a way as to foil justice, is also in the record of U.S. diplomacy, whether in the United Nations, where the United States has repeatedly exercised its veto power, and other mechanisms, other modes of persuasion and the like, to ensure that Israel has never been held accountable for any of its arguable violations of international law in regard to the Palestinian people, whether it's settlements, whether it's military attacks, whether it's violations of war crimes principles, or anything else. You may recall, those of you who are old enough, when Ariel Sharon, who was an Israeli military leader and then prime minister, was being prosecuted in under principles of universal jurisdiction in Belgium, in a domestic court in Belgium. Donald Rumsfeld, who was Secretary of Defense at the time, threatened Belgium with the withdrawal of NATO headquarters from Brussels if the Belgian legislature didn't amend its universal jurisdiction laws in such a way as to bar the prosecution of Ariel Sharon. And they complied. That was done, and it essentially brought that case to an effective halt. At least while Sharon was in office. It might have continued had he not had a stroke and then eventually died. But the case was effectively ended by this pressure from the United States. You may also recall more recently, and those of you who are a little younger, President Trump's imposition of sanctions on the ICC prosecutor and her family for her prosecutions for her investigation, I should say, opening an investigation of possibility of Israeli war crimes and Palestinian war crimes in the occupied territories. Now, this contradiction, this sort of the double standards, and the exercise of power in relation to international law is nowhere more evident today than in the situation, the contrast in how international law is being applied today to the situations in Ukraine and Israel-Palestine. Consider this: in just over a year, while the war in Ukraine is still raging, the International Criminal Court just recently, just in the last couple of weeks, issued an arrest warrant for the Russian head of state, Vladimir Putin. And this is under Article 8b, Roman numeral VIII, 8 of the Rome Statute, which defines as a war crime either it defines as a war crime the deportation of people from an occupied territory. And as I'm sure you know from the news, the allegation is that Russia has been deporting Ukrainian children, orphans, and others to Russia. Now, I must say, there is prima facie evidence of this crime. Let me also back up and say, I carry no brief for Vladimir Putin nor for Russia generally. There is absolutely no question in my mind that Russia's invasion of Ukraine was flagrantly illegal. In fact, constitutes the greatest war crime, as U.S. Supreme Court Justice Robert Jackson and Nuremberg prosecutor said. Aggressive war is the gravest war crime of all because it encompasses all other crimes. So, do I think that Putin is an angel? I certainly do not. Is he a war criminal? Quite likely, not more so than some American leaders, but equally, at least. Let me say, and as I was saying, I believe there is prima facie evidence of the commission of this crime of deportation of Ukrainian kids. There is also some countervailing evidence that the deportation may be justified under humanitarian grounds. The Russians certainly, they've been very open, very public about it. They seem to think that they're doing a great thing. Let's be clear. All wars are brutal, ugly, vicious, and typically involve arguable war crimes by both sides. We, US citizens, need to remember Abu Ghraib, Fallujah, and Guantanamo. When we, think about the offenses of others, we need to also think about our own record. And I have to say that this is the arrest warrant for Putin is a somewhat peculiar exercise of prosecutorial discretion. Now, here's the ultimate irony. This very same article makes it a war crime for an occupying power to transfer its civilians into the territories it occupies. In other words, it is under this very same article that it is clear that Israel has been committing a war crime to the tune of these 600 to 750,000 illegal settlers in the West Bank and East Jerusalem for going on 56 years. Now, the ICC, the International Criminal Court, has not been around for all of those 56 years. It only became effective in the early aughts of this millennium. But the Palestinians have been struggling to invoke ICC jurisdiction since 2009. And all that they have seen is a lot of legal hemming and hawing, and not a single arrest warrant has yet been issued, when the clarity and the scale of the crime is indisputable. And everyone knows this. Israel's own experts, like Theodore Meron, who was a highly respected Israeli jurist and who was in 1968 a legal advisor to the Israeli foreign minister, he told the Israeli government in that year clearly that creating settlements and establishing civilian settlements in the West Bank and in the Gaza Strip would be outright violations of the Geneva Conventions. So what explains this disparate treatment? Why this speed in the case of a possible but equivocal crime in Ukraine, and nothing but foot dragging in the case of Israel's blatantly illegal settlement project, now confined to the West Bank? Now, I've already alluded to some of the pressures on the ICC not to prosecute Israeli officials, and I'm certain that that's responsible for a considerable quantum of the delay. Meanwhile, here's what the New York Times had to say on March 18th regarding the arrest warrant for Putin. Quoting, "The court in The Hague acted unusually fast in this case. Key donors, including the European Union, sent money and dozens of prosecutors to speed up what is often seen as a plodding bureaucracy. So, justice to the highest bidder, the one with the deepest pockets? That's sure what it seems." Now, sorry if this seems bleak. I'm not here to be Debbie Downer. Let's now turn to the question of whether there is any reason for hope. Can the arc of the moral universe be bent toward justice in Palestine? And what role, if any, can international law play in this bending? And let's be clear, the arc doesn't bend by natural gravity. It bends by our agency. My answer is there is a role for international law. In fact, like it or not, law is not going away. And if we are not fighting in the legal realm for justice, I guarantee you that law will be used to enforce power. So in reality, there is no choice but to forge ahead, in my opinion. But we do have to start from a realistic appraisal of the weaknesses and shortcomings of law and international law in particular. and an understanding that there's no getting around, there's no dodging the challenge of building political power outside the courtroom as a condition precedent to positive outcomes within the courtroom. And also, of course, law isn't all about the courtroom. There is legal advocacy. There is public discourse. There's legal writing. There's there are op-eds to write, many different which can invoke legal principles, international legal principles. So I also believe that there is a way in which the blatant hypocrisy that we're seeing today, that I've referred to, especially acute in the case in the comparison between Ukraine and Palestine, that can be exploited, that can be used as a tool to sort of help people come to their senses. And I'm seeing evidence that this is occurring already. So, for example, Amnesty International released their annual report 2 days ago, and it begins with highlighting this acute paradox or double standards is the term that it actually used. So, the argument can be made, damn straight, indict, Putin. He is a war criminal, but let's make sure that we don't just indict, enemies of the West as a means of, prosecuting an emerging big power rivalry. Let's also make sure that we fairly prosecute based on the law and based on the facts, and not on who is committing the offense. I do want to stop within a couple of minutes, so let me just make 2 suggestions about how I think international law can be profitably, fairly, justly used in vindicating rights, not just for Palestinian people, but for all peoples of the region. One is about content, and the other is about form. Here's where I want to say a few things about the crime of apartheid under the Rome Statute. There are, I think, at the moment, at this juncture, that pushing forward with arguments regarding Israel's possible commission of the crime of apartheid against the Palestinian people, I think this is the way to go. So under Article 7 of the Rome Statute, apartheid is listed as a crime against humanity, and this is the language from that article. It means inhumane acts that are committed in the context of an institutionalized regime of systematic oppression and domination by one racial group over any other racial group or groups, committed with the intention of maintaining that regime. Why do I think this is an important article for Palestine and for advocates for justice in Palestine? Well, there are both legal and political reasons. First of all, this article was drafted after the formal end of apartheid in South Africa in 1994. So clearly, it is not about the South African version of apartheid, and that helps us avoid the rabbit hole of comparing what's going on in Israel-Palestine with how apartheid looked in South Africa. Many defenders of Israel will say, well, you don't have separate bathrooms, you don't have this, you don't have pass laws, this, that, or the other, you don't have these other specific characteristics of South African apartheid. These are totally different things. Well, the definition of apartheid that I just read you makes no reference to South Africa, nor to any of South African apartheid's specific characteristics. It's quite general. Another important feature of it is that, in contrast, for example, to the crime of colonialism, which some people argue is actually a better way to go than in Israel, Palestine. In contrast to the crime of colonialism, there is no geographic limitation to this offense, and there is no reason in the definition of the crime itself that it cannot comprehend Israel's treatment of the Palestinian people as a whole. And there is by now a powerful consensus and body of factual data and legal analysis compiled by local and international NGOs, from B'Tselem to, Amnesty and Human Rights Watch. And then finally, as a political matter, it also connects with a tradition of, in the anti-apartheid movement, and with a set of tactics, specifically boycotts, divestment, and sanctions. Now, there's the other thing I was going to mention, and I'm now going to skip to give you an opportunity to ask questions and make comments. The form requires integration of legal struggle along a variety of axes. And I would simply, at this point, maybe we'll come back to it in discussion, but I would refer you to my paper called Justice for All, Toward an Integrated Strategy for Liberation in Palestine, which was published in the Palestine Yearbook of International Law, in which I go into the various forms of integration that I foresee as necessary. Under the best of circumstances, and I'm now concluding, we should not assign nor rely upon law as a principal tool in the struggle for justice for everyone who today lives between the river and the sea. That should be our objective, however, justice for all, not just for Palestinians, for everybody who lives between the river and the sea. To quote civil rights icon Bayard Rustin, unjust laws and patterns do not change because Supreme Courts deliver just decisions. Social progress comes from struggle. All freedom demands a price. Thanks for listening. I look forward to your comments and questions.
Thank you, Dr. Bisharat. That was very thorough and somewhat bleak, but left with a positive note. You preempted some of my questions that I had coming into this lecture, which were going to be cynical questions about the role of international law in particular, and law in general, in defending, or at least stopping and preventing the oppression of the underprivileged. So I'll ask a question, and while I do, I'll encourage the audience to use the Q&A in the Zoom function. And I want to take it to 2022, 2023, right? Or 2023. There's a lot going on in Israel right now, right, within Israeli society, and lots of protests and intra-community strife among Jewish Israelis. And at the same time, there doesn't seem to be any progress whatsoever in terms of a Palestinian state ever coming to fruition, or even the end of an occupation. And so you've been working on this issue for decades, and there's been 2 intifadas. There's been multiple rounds of international negotiations, from the Oslo, Madrid peace process, the Oslo agreements, and it's a stalemate at best, and it's gotten worse for the Palestinians in terms of more settlements, more home evictions, Gaza being an open air prison. So what do you have, what insights do you have for the new generation of people from across the world and of different religious backgrounds, whether they're Muslim, Christian, Jewish, Hindu, any other faith, who truly believe that the occupation is unjust and needs to end, and who also believe that Palestinians are humans who deserve basic human rights. What is your prognosis for the future?
Well, my prognosis is that it will get worse before it gets better, unfortunately. I agree with you that the circumstances on the ground today are worse for Palestinians than they ever have been. This is true not only for Palestinians living in the occupied territories, it is also true for Palestinian citizens of Israel, and it is finally also true of Palestinians who live outside, in exile, outside of the borders of former historic Palestine. Many of them, as I'm sure you know, whether in Lebanon, Syria, Iraq, Kuwait, have all been subject to, to further rounds of exile and devastation in their host countries after fleeing Palestine in 1948. So it is a very rough reality that we are facing today. I see hope, however, in a number of different ways, and I actually see hope in what's going on within Israel today. If you want to know the truth, I have a lot of admiration, and I am inspired in some ways by the brave Israelis who are going out in the streets today and are laying it on the line for what they see as a fight for democracy. Now, is it a fight for democracy for all? No, not at this point. It's a struggle for, I characterize this in a piece that I wrote with my colleague Jamil Dakwa that was in Haaretz last week. This is a struggle over who will administer an apartheid state over the Palestinians. What version of apartheid will we have? A frankly racist one, or one that's not quite as frankly racist and brutal? But, there is a possibility for partnership between Israelis who are genuinely committed to preserving their vision of democracy and Palestinian people. The reality is the two societies, they're not two societies, they're one society. They are one integrated unit today, and they will never again be separated. There will never be a Palestinian state. Anyone who believes that, I was going to say something cynical or sarcastic, but I'll save it. It's just not realistic. And we have 30 years of experience now with the so-called Oslo peace process that resulted in all process and no peace, and diminishing scope for the creation of a genuinely sovereign Palestinian state. And so we are dealing with a one state reality. We have been for quite a long time. And the question is, will this one state reality continue to be governed by a regime oriented around apartheid principles, or will it be a democracy predicated on equal rights for all people? And if it is, let me tell you that will be a dynamite development and an incredibly positive development for the region as a whole. There is so much to be gained in partnership between Palestinians and Israelis if Israelis in particular can be convinced to see Palestinians as equal human beings entitled to the same rights as they are.
Thank you so much, Dr. Bisharat, for your insightful and comprehensive comments and analysis. It's much needed. We need more discussion, not less, on international law, and especially on Palestine, Israel, and especially on the experiences and the perspectives of Palestinians, which unfortunately don't get enough coverage in mainstream media. So I just want to thank you. I want to thank our audience for joining us. I want to encourage our audience to follow us on social media at RUCSRR and Rutgers CSRR. And also we have all of our past lectures, including this one, will be added to, is on our YouTube channel, which you can find on our website. And hopefully we'll see you at our next event, which is on April 24th, featuring Professor Tanya Hernandez giving a book talk on anti-Black racism within the Latinx community. So thank you so much, Dr. Bisharat, for taking time and generously sharing your expertise.
It was my honor. Thank you very much.
Thank you. Assalamu alaikum, everyone. Ma salam.
Masala.